Carol versus Carol.
So I've read your motion relative to custody, and let me ask Miss Carol if you received a copy of that as well.
I did. It's postmarked the 12th. I received it on the 14th. Assuming that's proper service of process. I'm not sure, but I did receive it.
It's somewhat. The court rule says 7 days by personal service, meaning it's placed into your hand, or 9 days by mail, and it's really not when you got it. It's when it was mailed. Now this says that it was mailed on 11/7. Is that correct, Mr. Carroll?
I don't have a copy of when I sent it. It was a couple days after I had filled out the paperwork.
Okay, so you signed this. It says, I certify that on this date, and you dated it November 7 of 2024, I served a copy of this motion, a Uniform Child Custody Jurisdiction Enforcement Act affidavit, and a notice of hearing on the parties or their attorneys by first-class mail to their last known addresses defined in Michigan Court Rule 3.203, and you signed that. Okay, so did you, the proof of service, which is what we go by,
Yes.
was dated 11/7. Did you not mail it on 11/7?
As 11/7 would be the date that I filled it out. And it went out a day or two afterwards. I did not get it into the mail right away.
Okay. So if it were sent on 11/9,
Yeah.
days, that would still be proper service. It has to be, like I said, all it has to be is sent 9 days before, not that it actually is received by the person 9 days before. Does that make sense, Ms. Carroll?
Yes, it does. Thank you.
Okay. So I've read the motion. I've also read a response to the motion. And did you get a copy of that, Mr. Carroll?
I did. Yeah, she handed one to me when I picked him up.
Okay. So let me tell you what I know, and then I'll turn things over to you. Okay.
Yes.
So what I know is that the last order regarding custody was the judgment of divorce between the both of you, which is dated June 5 of 2020. And what that provides for is it provides that the parties will share legal custody, and that primary physical custody would be awarded to the plaintiff mother. The items that I, and both of you, just to tell you what the law says, before I can stick my nose in your business again, especially as something as dramatic as custody, you have to meet what's called a threshold. And the rationale behind that is that custody is such a destabilizing thing that they don't want people just filing these motions every other week. It has to be something really significant. And that is set forth in the case of Vodvarka versus Grassmeyer, 259 Michigan Appeal 499. So I need to have, before I can do that, I need to have proper cause, meaning something must have a significant effect on a child's life and be legally sufficient and be of a magnitude to have that significant effect on a child's life and be relevant to one of the risk factors. I need to change a circumstance which says that the person must prove since entry of the last custody order that conditions surrounding custody, which could or would have a significant effect on a child's well-being have materially changed. So what I read in your motion was the following were listed as proper cause or change of circumstance. First, that you and your son want to spend more time together. That's a laudable goal. And I would doubt nothing but that. I'm sure you're a wonderful father, and I'm sure you have a wonderful son.
I appreciate that.
But that's not enough to get me to stick my nose in custody again. The second thing is you became self-employed. Once again, that's something that might have a material effect on you, but it really doesn't have one on, and I'm going to use the 7-year-old's initials, OC.
Yeah.
So the two requested reasons to stick my nose into your business as far as custody go don't amount to something called proper cause or change of circumstance to review custody. But there was something in your motion that caught my eye. It mentioned that the plaintiff, in this case, Ms. Carroll, was resistant to efforts to try and mediate a resolution to this. Is that correct, Mr. Carroll?
Yes, sir.
All right, let's find out why. Ms. Carroll, your thoughts. Why would mediation not be an appropriate way to resolve some of the disputes existing between you and Ricardo?
So I think I had mentioned in my response that there were only requests for mediation from Ricardo when there was an event that came up where I had to reach out to him, such as recently, he's been coming back from his father's house incredibly sick from his allergies and asthma due to there being a cat there. So I reached out to him and I said, he's missing school again. I'm missing work again. I just want to let you know there's an allergy pill you can give him so that to prevent the symptoms if the cat must be there. And he did not respond to any of my concerns. He actually said the cat is not there, although according to the son, it is. And so there's only mentions of mediation during conflict when we're unable to communicate properly. I do not feel safe with him. He has harmed me physically and emotionally. I feel like the only time that it's even suggested is when something is brought up and ignored. So that just leads me to believe that I would have difficulty getting anywhere with him in mediation as far as coming to an agreement because we cannot communicate properly.
Well, you have a son, and both of you chose to place that son on this earth. And one of the duties that you both have as parents is, in addition to supporting, making sure they're warm and fed and all those good things, is to co-parent with the other parent. And that's a requirement, especially when the parties have joint legal custody. That means the parties need to be able to pick up a phone and contact the other person and say, okay, we have a problem. He's coming back from your house ill, and it might be because of the cat. If there is a cat and he's allergic to it, keep the cat away from him, give him a pill, get rid of the cat. There's all kinds of things that can be done. But it troubles me that two very nice people, I mean, by far, I don't think you and I have ever met, either one of you, which means that so far you both have managed to at least try and work things out. But what troubles me is that the parties cannot seem to communicate with one another. And that's troublesome because that is going to create problems for your son going forward. Even though you don't intend it to happen, but it does. Your son is, and I don't know whose fault it is. I mean, it takes two to tango. So I don't know if I can lay it, at one person's foot or the other. But this is what I'm going to do, Mr. Carroll. I'm going to try and see if I can't come up with a way to get you both back to some sort of healthy communication for your son's sake. Not for your sakes. You two are adults. You guys can roll with the punches. OC cannot roll with the punches. He's just a little
Correct.
guy, only 7. So here's what I'm going to do. I'm going to respectfully deny your motion to change custody because I don't believe I have a threshold. But I am going to order that the parties enroll in and participate and communicate with something called Our Family Wizard. Our Family Wizard is a communication platform that does more than just communicate with one another. It keeps track of appointments. People can post things about school, about doctor's appointments, about all that stuff. And it does cost money, but they also have a service where they can grant waivers to the cost based on the party's income. So it should never be a detriment to doing that. And you can get that, I think it goes by the acronym OFW, Our Family Wizard. And if you put that into your search engine, you will find it. And I want you both to go on that. I want you both to sign up for it. Pay whatever fees you got to pay, or if you can get those waived, more power to you. And that is how I would like you to communicate going forward. That way that there's no problems with anything. You don't have to talk with one another. You can. There's nothing prohibiting you from doing that, but this is a good way to at least get the door open to communicating. So I'm going to order that. And you
May I
can,
ask?
well, hang on a second. Let me.
Yes, sir. Yes, sir. Of course.
There's requirements there that you have to respond back within 24 hours unless it's an emergency. Then all bets are off and you can text one another, that type of thing. So what I need you to do, Ms. Carroll, is prepare an order denying Mr. Carroll's motion to change custody and ordering the parties to enroll in and participate with Our Family Wizard, and the parties will enroll in that within the next 21 days.
Okay, is there a certain time that I need to prepare the order?
While you prepare the order, you can go down to the 5th floor Legal Assistance Center at the courthouse, and they'll show you how to prepare that. And then you send a copy to Mr. Carroll, and then if there's no objection, and you can't object because you don't like what I said. You object if it's not worded right. Then once you get that, there is a 21-day objection period because the judge has to, would be entertaining if either one of you didn't agree with that, with what I did. A judge would hear it ultimately. But I would think if you went in there maybe next week sometime and prep that order, send a copy to Mr. Carroll, and take the weekend to go on Our Family Wizard and explore it. I mean, it's a wonderful platform. It uses, you can post stuff. It has calendars. It has all kinds of things, and it monitors. There's also what's called a tone meter you can enroll in. What that does, if somebody sends an inappropriate message, it'll kick it back to you and say, yeah, you might want to rephrase that. Okay.
Okay,
Let's try this for a while, and then who knows? Maybe we can get you two back to chit-chatting about your son. I mean, you both don't need to care for one another. I'm sorry that you don't, but I know there's a lot of water under the bridge between you two. I can't unring a bell, but I can try and go forward. And I think that's what your son needs is both his parents
I agree.
to at least see eye to eye. Don't put your 7-year-old in a position of having to have 2 birthday parties, 2 bar mitzvahs, 2 wedding receptions, all this stuff. Um, you know, you guys got to learn to at least tolerate one another for your son's sake. You're not together anymore. I get that, but you're always going to be parents to this little guy, and this little guy deserves 100% his parents being able to sit in the same room and communicate about him. That's just what he did, I think. Okay,
okay, I
Yes,
do have one more question, if that's okay.
maybe, go ahead.
In regards to this being our main method of communication now, does that, I have had an issue in the past with him texting me almost daily, to speak to Oliver, which is okay if Oliver would like to. Typically, he just does it kind of later in the evening or very, very early in the morning. Is that something that can stop and we can use the app for them to communicate, or?
You can do that. I don't know enough about the inner workings of our family wizard to tell you if it has a place where the child and a parent can communicate. It's designed really for parents to communicate. Obviously, if there's nothing in your judgment as far as phone communication with your son, I always use the term reasonable telephone contact. So you can't text and ask to speak with them 17 times a week. You can't call or text at midnight and say, hey, can you wake them up and put them on the for a minute? I mean, it has to be reasonable. And I don't always know what is reasonable, but I know 2 people on this hearing this morning who know your son and both of you better than me. And that's both of you. You both know what's reasonable. You know, I mean, that's what it's designed for. Remember, this is only a temporary thing. It usually goes for a year. Then you have to renew it. But I'm hoping maybe in this year, and it doesn't apply to emergencies. Obviously, if emergencies happen, you need to get a hold of somebody right away. Then you need the ability to be able to reach out. But otherwise, a majority of your communication should be through this. I hope that answers that.
Yes, it does. Thank you.
Okay. Good luck to both of you. Have a wonderful Thanksgiving. Give my best to OC. Sounds like a really nice kid.
He is great.
Thank you, Your Honor. May I ask a question too, please?
Sure.
I was told by Ms. Bowen at FOC that this would lead to a review of child support as well, as I make about half of what I did a few years ago when we went into this first agreement.
Okay. Ms. Bowen is not, well, actually, she is an attorney, but she cannot give that kind
Oh,
of legal advice.
of course.
The only thing in front of me today, Mr. Carroll, is the motion for custody. So
I was told that it would do all of those things. I wasn't totally sure.
now, if you want to file a motion for me to specifically look at child support, what you need to do is you need to file that motion, and then you need to tell me what has changed since your judgment in 2020, whether it's your income, whether it's Carol's income, whatever it is, and do that. You're also entitled to a 3-year review if you just go to the front of the.
That is what I got, and I have a letter for her, but when I spoke with her on the phone and I explained that I was going to try and get equal time with him, she said, if you're going to do that, then it probably starts I don't think she said probably. She said it starts a process of a full review as well. And I'm not sure what the,
Okay, so since I denied that, you better go with Plan B and do your
I will.
okay?
Yes, sir.
Best of luck to both of you.
Thank you so much, Hunter.
First on my screen is Javante Deans. Mr. Deans, our defendant in this matter. Good morning.
Good morning.
I have received a motion relative to custody from Mr. Deans. Ms. Palmer, did you receive a copy of that?
No,
Mr. Deans, how did you go about serving pursuant to Michigan court rules, Ms. Palmer with a copy of the motion?
By mail, sir.
Okay. Do you have her correct address?
Yes, sir. With the amount of documents that I'm presenting in this case, I had to use a yellow envelope. So when I sent it off, I only put 2 postage stamps on it. So they sent it back. So I had to put another one on and send it back off. So it might have showed up. It's guaranteed in her mailbox for sure. I don't know if she checked it, but I mailed it off earlier this week when they sent it back.
Okay. Well, let me explain what the court rules require. And this is found at Michigan Court Rule 2.119. The court rules say that you have to give notice and what's called serve a person a copy of your motion. If you're doing it by mail, they have to receive it, or not receive it, you have to mail it 9 days before the hearing. If you're going to have it hand delivered to the person, it has to be done 7 days before the hearing.
Mhm.
So if you got it back in the mail and didn't put the correct postage on until this week, that would not be enough time for me to hear this motion today. You would have to reschedule it and serve her correctly, meaning you'd have to put the correct postage on it at least 9 days before in the mail, and or hand deliver it through a process server or somebody like that at least 7 days before the motion. You pretty clear on the directions for that?
I am clear on the directions for that. It was just a mistake on my end on the postage stamps, I guess. I don't know how she found out about the court date if she hasn't received the paperwork.
I received the text messages, let me know I had a Zoom meeting today. I received it actually the day before yesterday. So I just showed up because it said what time to show up.
Did you happen to check your mail?
I didn't see it in my mail. I didn't check my mail yesterday. Before yesterday, I didn't check my mail, no. But I checked it earlier that week, but no, I didn't check it the day before.
But it really doesn't matter if she did. See, the problem is this, Mr. Dean, is if I were to do anything relative to your case and service wasn't proper, then it just gets undone and then we start back over. And I don't want to put you through that exercise, and I don't want to put Ms. Palmer through that exercise. So the best way to do this is to reschedule this. You can go to the 5th floor Legal Assistance Center. They'll help you do that. Reschedule it. Make sure it's mailed to Ms. Palmer at least 9 days before. And we will reconvene, or you can serve her by hand 7 days before. One of the
I'll just mail it off. I don't get to see her in person.
Okay, then probably the mail would be the best bet, but just get it there in plenty of time. And if it's a lot of paperwork, and I would go down to the post office and have them weigh it, make sure you get the correct stuff on it. You don't have to send it certified, but if you do that and you have a receipt from the post office about that you mailed it, then that's if it's 9 days before, then you're good to go. Okay, that's what I would do. That makes the most sense in this. but you can go to the 5th floor Legal Assistance Center and they'll help you renotice this, okay?
Okay, so if one party doesn't receive the paperwork, then the process can't go on correctly.
No, that's not true. The process can go on. It's just if the person was served properly and just either chose not to receive it, didn't open their door for a process server, left it sitting in the mailbox for 9 days, whatever. As long as it was sent to her last known address at least 9 days before, then the burden becomes on her to get it. And like I said, the best thing to do is not to guess, is to go to the post office. You take an envelope there and you have them weigh it, and they will tell you the exact proper postage to put on it, and then you got no worries. Okay?
Right.
Everybody makes a mistake once in a while.
Right.
I mean,
And if I can,
I'm sorry.
I do have a question.
What can I do for you?
You say that this motion is for custody, as in if you're trying to get custody of the child?
Well, that's what it's captioned.
Oh, okay. I just was confirming.
I don't know what I've read it, but people sometimes caption things different than the way it really reads. So I'll wait for you to get a copy of that, and then we'll chit chat about it when we come back again. Okay?
Okay, no worries.
Have a great holiday, both of you, and we're adjourned. You can sign off. I have read your motion. Let me first ask if you have had a chance to read that, Ms. Robertson.
Yes, I did have a chance to read it.
Okay. All right, well, I have a couple of questions, and then I have to tell you about a policy. First question is, didn't I previously sign off on you moving to Virginia?
Yes, that happened, 2015. I was supposed to be moving with my mother, and my mother passed away. So I didn't end up moving.
Okay. Because I swear, when I was looking at this going, I remember this from way back.
Yeah, you're correct.
So the next question I have is for you, Mr. Bolden. When I checked your case yesterday, an alert came across my screen. And when an alert comes across my screen, that means there's a bench warrant for your arrest. Are you aware of that?
No, sir.
Okay. Apparently there is currently a bench warrant for your arrest regarding non-payment of child support. All right. So I can't hear this motion until until you get that cleared up, because anything other than that, I can't make orders regarding a child in the care of somebody who has an active warrant for their arrest. Because obviously, if they pick you up, what do I do with the child at that point? So that is the problem. So what you need to do is contact your caseworker at the front of the court and make arrangements to get that heard with the judge. And then once that's resolved, I can entertain whatever motion you want me to. Okay?
Mm-hmm.
All right. Now, let me just say this also. It looked like in your motion that both you and Ms. Robertson were somewhat agreeable to the things in your motion. Is that accurate, or did I misread that?
No, no, it's not accurate.
Okay. All right. Because it seemed to intimate that. So here's what I need you to do, Mr. Bolden. I need you to clear up that bench warrant. Then you can bring this matter back to me once that's cleared up. And then I will, entertain, your motion, at that time. Okay?
Okay.
All right. You are all set, both of you with me. Have a wonderful holiday and good luck getting that squared up, Mr. Bolden.
I appreciate it.
You bet.
Thank you.
So, on your motion, it says that, you served a copy of your motion and all the attachments to it, to Ms. Gomez on October 28th, 2024. Is that true?
Oh, yes, to the friend of the court, to Gonzalez.
Okay. Does she have a confidential address?
Yes,
Okay. So you gave it to the friend of the court and they would send it to her. Is that what you're telling me?
correct.
Okay. Did the friend of the court send you what's called a proof of service that they did that?
Yes.
Okay. So you have a proof of service that what does the proof of service say about when they sent it to Ms. Gonzalez or to Ms. Gomez?
They just sent it in the mail saying that they served her the paperwork.
Okay, so they've acknowledged that they sent it in plenty of time, pursuant to court rule, so I can hear this motion this morning.
Yes, because I gave them the paperwork the same day I filed. I went straight to the friend of the court and gave it to them.
Okay.
And then I got in the mail.
That was on the 28th of October, right?
Correct.
Okay. And the reason I'm asking this is because she's not here, obviously. And that always concerns me when someone is not here. But I read your motion, and I do have some questions. Let me tell you what I know, and then you can tell me what's going on.
Okay.
So the last parenting time order was entered not that long ago, was entered in August 8th of 2024. And on page 2 of that order, because I went and got myself a copy of it, it has a parenting time schedule, and it also has a October 15th, 2024, that apparently the counselor is supposed to speak with your child, who is now 13. They're the ones that are supposed to weigh in on that holiday parenting time. Has that happened yet?
I went to the counselor and I kept trying to set up the mediation and I can't get nothing set up. Because it was supposed to, because my lawyer, Kelly, he closed my case, he set up so we can do a review for more parenting time for the middle of October, and it never got set up.
Okay, so
And then,
mediation was never set up.
yeah, and that's what I'm trying to get set up so I can get more parenting time.
Then I will order mediation pursuant to 3.216 to occur within the next, or at least get it scheduled within the next 7 days at the Dispute Resolution Center of West Michigan. I will find out if I have to do a form for that, but we will get it over there and we'll get this thing in motion for you, okay?
Okay, and then we're supposed to have a new counselor because he doesn't specialize in it, and he recommended some people, and I tried to get the counselors. I sent it to her, and she never answered of which one she wants to pick.
Well,
So he doesn't have a counselor right now.
let's have the mediator pick it then, okay?
Okay.
Mediator pick it. I will find out if I have to do an order. See, what's the Dispute Resolution Center works with parties' incomes. So I will order that mediation occur there, and that they will also select from a list a new counselor for your child. So,
Okay, thanks.
what I need you to do, is I need you to prepare an order to that effect, okay? So here's how you do that. You go to the 5th floor Legal Assistance Center and tell them that I ordered the parties attend mediation at the Dispute Resolution Center. And at that mediation, to discuss holiday parenting time and a new counselor. And that's to occur within the next 7 days. So you write that all into a form of an order, you send it to her, and then if there's no objection, I'll sign it, and then it will become an order of the court. That's something enforceable, but the Legal Assistance Center can help you through that, okay?
Okay.
All right.
And
So,
what was the name of the file I have to file with the 5th floor?
it's called it's called an order after motion or an order after hearing,
Order after hearing,
right?
mediation.
Yeah. Okay.
Thank you.
You bet.
Appreciate it.
Good luck to you, Anthony.
Thanks.
You bet. Have a good weekend.
Are you too?
So, I'll state for the record, that a complaint for custody was filed on June 12 of 2024. It was served on, September 11 of 2024. A default was entered against Mr. Polar on October 11 of 2024. A motion to enter the default judgment of support was filed on October 18th of 2024 and set for today. I do note from the proof of service that Ms. Yarborough did comply with Michigan Court Rule 3.210B4A in that she sent a copy of the proposed judgment of support on the 18th of October, along with the other materials. The child support, as calculated by Ms. Yarborough, amounts to $161 in base support per month, 18 in ordinary medical, for a total of $179 per month, starting upon entry of this judgment. The uninsured medical split is 52% for plaintiff, 48% for defendant. So let me turn to you first, Ms. Yarborough, and then I have some questions for both of you. So
Okay.
is there anything you'd like to add, Ms. Yarborough?
No.
How about you, Mr. Polar? Anything you want to tell me?
So yes, on the paperwork that I had received, she had put down that she has him 200 days out of the year and I have him 165. Currently I get him every single day of the week, but for Saturday and Sunday. And Friday, when he gets out of school, he goes with her father. Therefore, she gets him 3 hours a day, Monday, Tuesday, Wednesday, and Friday, or Wednesday, Thursday, and Friday. And then I want to know how she calculated that she has him 200 and I have 165.
Okay. Anything you want to add on that, Ms. Yarborough?
We came to an agreement because I do work third shift. So he has a Monday, Wednesday, and Thursday during the week. At nights while I go in at work, he has them from 7 until my son starts school. And then like summertime, I have them all day before I go into work. But 4 days out of the week, I do have them. Tuesdays, we had an agreement that he would go with my mother to spend time with her.
Okay. So, who helped you calculate this child support?
We did it on the calculator at the front of the court.
Okay. All right. Is that is that your understanding? David, you and Caitlin did this together?
No, we did not.
I have a text message asking if he would have him or have my son go to my mom's on Tuesdays. He does have them during the week, yes, but at 7 p.m. until he goes to school.
Okay.
Okay, so this is how it works. So
I
I'm
don't know. Hang on a second, David. I really don't need to know how it works. Because I'm going to do a couple of things, first of all.
okay.
I'm going to enter this because I find it to be fair and equitable in the best interest of your 5-year-old. But I understand that the child support, whenever a couple of people who are not represented by attorneys start digging into child support, it's a confusing area. So what I'm going to do is enter this, and then I'm going to do a separate referral to the front of the court to do a complete investigation and recommendation to me as to what the child support should be. They're going to dive in and ask for income information. They're going to dive in and ask for the amount of overnights. They're going to tell you ask you how you came up with that. So they're going to do a real deep dive into it and then come up with what the correct amount should be. And then the parties are free to either accept that or they're free to bring it back to me and explain why that's not fair. Okay?
I do have a question because our son does receive Medicaid.
Yeah.
So
Yeah.
I didn't, does that go into it too?
Well, that's up to the friend. The friend of the court has to
Okay.
score that.
Okay,
So they'll keep track of what they need to do as far as doing that is concerned. But you should be hearing from the friend of the court within 7 to 10 days, and make
Okay.
sure you have. There's no cost to it, so you don't have to worry about anybody coming up with any money. But I will go ahead and do that order referral today. I will sign that. Okay?
Yep.
Let's have the front of the court address some of Mr. Polar's concerns. Because
Okay.
I don't want anybody paying more than the guidelines state, and I don't want anybody accepting less than the guidelines state. Okay?
Yes. Yep.
All right. I will do that. I'll sign this, and then we'll sign an order picking the child support for an investigation.
Okay, thank you.
All right, you bet. Thank you both very much, and we're adjourned. Thank you. Assure everybody is that I have read every one of these motions, and I have read every response. So you don't have to just simply go over your motion. I've read it. And I've read every response that I've gotten to it. First on my screen, is attorney Bruce Block with his client Brandy Pinkney. Mr. Block and Ms. Pinkney, good morning to both of you.
Good morning.
Good morning.
And Mr. Peterson now joins us on behalf of his client, who is also with him, Mr. Juan Posada. Mr. Posada, Mr. Peterson, good morning to both of you.
Good morning. Good morning.
I've read your motion, Mr. Block, and I've read your response, Mr. Peterson. Did you get a copy of that response, Mr. Block?
I did.
Okay, then I'll turn things over to you. Anything you want to add, highlight, I'll turn things over to you.
Just, I know you don't want us to go with emotions, so I'm not, going to. Obviously, there's a lot of cases here today. We're talking a period of 9 months. The plaintiff has had the daughter once for an overnight on a camping trip on July 12th. He states in his answer that he's been denied parenting time. However, he doesn't ask for it. And you can't be denied something you never asked for or you never arranged to come get. He repeatedly makes plans and never shows up. Right now, he's living with a girlfriend in a 2-bedroom apartment, apparently. The girlfriend, according to my client, has had her kids taken away. In this past August, plaintiff was accused of rape apparently by this same girlfriend he's living with. In paragraph 2, he says he's on a waiting list for a 3-bedroom apartment. That is false. He got denied for that apartment because it is apparently based on income, and he makes too much money. At no point did Miss Pickney agree to that they would just simply have a pause in parenting time, except in March when plaintiff was at 6 weeks in an intensive outpatient unit for drug addiction. My client believes April through August, plaintiff was continuing to do drugs. I think meth is his drug preference. The long and the short of it is the schedule is just not being exercised by plaintiff. He's paying no support. And there simply has, I believe, has been a change in circumstances such that the custody issue and child support issue should be reviewed again. You know, I did, as I said, I've read the answer, but, you know, my client spoke, the principal from the daughter's school called her up and said, some guy called, said he was the father of this child, your daughter. You know, he's never spoken apparently with the school about the daughter. And, you know, that's his choice, obviously. If he doesn't want to, he doesn't have to. But I believe we have shown a sufficient threshold showing to be able to get this to a hearing on the issue of parenting time, custody, and child support. Thank you.
One question that I had, Mr. Block, is your client knows, quite frankly, an uncomfortable amount of details about the plaintiff. How does she know all these?
I'm not exactly sure, to be honest with you. There's a lot of phone texts back and forth. And I believe they, maybe she has people that are friends with the plaintiff. I don't know. I would have to ask her. I don't want to do it on the record. I mean, you can ask her if you want.
No, I probably will at some point in time. It's just, I don't know if these things are on information and belief or if these things are fact. But that just seems to me there's a lot of information that your client has, and I'm just wondering how she would know that. But I will ask Mr. Peterson if he has any idea. Mr. Peterson, I read your response. Thank you. Anything else you want to add?
Well, I guess I would just start with that question that you had for Mr. Block. I think she knows a lot of information because these two are in contact with one another. My client confides a lot of things in her. They do communicate fairly well at most times. My client has been paying support. He's working at Ventra, that he's waiting for the income withholding order to take place at Ventra. He's in his first couple of months there at Ventra. He has provided all that information to Ventra to make sure that that happens. In addition to what he owes in child support, he's been providing Brandy with additional money. He was paying her $50 a month for several months for school clothing and any other thing that she needed. He is working at Ventra. He's in a 90-day probationary period right now because he just started working there. He will have health insurance available for himself and for the minor child in this case by the end of this month. He has been drug testing and he's clean on all of his drug tests. He has not failed a drug test since August. He didn't fail one in August either. I'm just stating that he hasn't failed one since August because those are the only drug test results that I am looking at here. He did have some issues with housing back in April of this year, and that's what started all this. Back in April of this year, he had a girlfriend. They ended up breaking up. And my client and Brandy entered into a verbal agreement that he wouldn't have parenting time because Brandy was living in Ionia. My client was living over in the Lowell area, and he didn't have transportation to get back and forth for all of his parenting time. They remained in constant contact. He did have a relapse with methamphetamine, and that's why he's in individual counseling through Pine Rest. He did enter into a 6-week treatment program there. He continues to treat there, and he's doing very well with his treatment. He's been asking for parenting time back, and Brandy simply refuses to allow him to see the minor child, other than a few times where she has allowed him to take the minor child for a dinner, take the minor child to a event at the Ionia Free Fair, and a couple other times. It's simply not true that he makes plans and doesn't show up for requested parenting time. He's not getting that parenting time. My client did recently get involved at the new school for the minor child. He did that in anticipation that his parenting time would start up again at some point. He wants to be involved at school. He went to parent-teacher conferences. He has this Dojo app that the school uses to communicate with parents. He's been doing fundraising for the minor child through the school. He has been doing everything he can now that he's in a good place, Referee Winther. There's no doubt about it. He was not in a good place earlier this year. He admits that. He's told Brandy that. But he is excelling in his recovery at this point. He's not unrealistic about parenting time going forward, and that this would just jump back into the 50-50 equal parenting time. I've had that conversation with him. He's just looking to see his daughter, whether it's in a supervised manner at this point for a little bit. He would be open to that. He wants to see his daughter get back into her life and keep working on his recovery.
Mr. Black, I'll give you the last word.
Child support is $24 a month right now, which is just horribly inadequate. Obviously, we don't have time, but my client has a log of phone calls and what was said going back to probably back to June. And I'm glad he wants to be involved, but we need some kind of a schedule, Referee Winther. I mean, and he needs to keep that schedule, and he obviously needs to be clean and sober too. She does not at all want to keep daughter from dad, but dad needs to make the effort, and we need some kind of a structure, if you will. I think would probably be ideal here. Thank you.
Thank you. Well, the motion cites that there is proper cause or change of circumstance pursuant to Voldvarka versus Grassmeyer, 259, Michigan Appeal 499, a 2004 case. For me to once again become involved in the party's custody matter. By this court's order dated April 15th of 2020, the order provides for joint legal and joint physical custody, quite frankly, along with an extensive order of parenting time. And it is, from my recollection, 2255. The reason cited, if I could boil these down, is first, plaintiff doesn't exercise all his parenting time. He's only had one visit since July. Obviously, if I'm to believe Mr. Peterson's client, he didn't do that because he was in the grips of an addiction, and that would prohibit him from doing that, or that he's been simply refused. The second one is that he doesn't attend doctor's appointments or school activities. Sounds like he's trying to re-engage with the school. Medical appointments is a whole different story. Generally speaking, I don't normally hold that against parents because that's how life works. Most people only have one parent show up to their medical appointments. Sometimes having two is a possibility or is a problem. The third issue was possible drug and alcohol problems. Time to believe Mr. Peterson's client, he has tested clean in his last drug screen. I'm happy to hear that as far as that goes. I agree with Mr. Block to a certain extent that obviously we need structure, and the child support seems woefully short of expectations. I don't believe we have enough under vote Barca to change custody, and I'm going to respectfully deny that. However, under the more relaxed probable cause standard of Shade versus Wright, 291 Michigan Appeal 17, I do believe proper cause and or change of circumstance has been shown, because clearly the parties are not cooperating with parenting time. And I believe that does constitute a change of circumstance relative to parenting time. The relevant best interest factor could be found at MCL 722.23J as in John, because it diminishes each parent's ability to encourage a close and continuing parent-child relationship between the other parent and the minor child. That was set forth in the unpublished case of Bauman versus Hartman, although it's unpublished and not binding for purposes of stare decisis. I do find it to be persuasive to me. So I am going to reopen the issues of child support and parenting time and refer those to the Kent County front of the court for an investigation and subsequent recommendation. I am going to also order that the parties attend mediation pursuant to 3.216 to discuss an interim parenting time schedule while we're waiting for the front of the court to do their work. If the parties cannot come up with their own interim parenting time order, then either Mr. Block or Mr. Peterson can bring that back to me, and I will adopt one. Generally speaking, I don't like to do that. It sounds like Mr. Peterson acknowledges that we have to crawl before we walk, so it's going to take a little time, and I'm hoping that cooler heads prevail at mediation. I'm sure the parties through their counsel can agree on a mediator. If they cannot, then you may contact the dispute resolution clerk at the county, and that person will give you next up in the rotation. I'd be very careful with that, though, because you could end up with a psychiatrist in Farmington Hills. That's happened before. Mr. Block, can you prepare an order to that effect, please?
I certainly will.
And is there anything further from you?
The front of the court fees, is that gonna be divided?
Yeah, I'll split those. I'm sorry, I didn't cover that. I'll divide those.
Very good. And I will also, Mr. Peterson, I'll be contacting you. Maybe we can get something worked out between us.
I'll be here all day.
All right, very good. Thank you.
Thank you.
Twice on Sundays, apparently. Anything further, Mr. Peterson?
No, thank you.
All right. Good luck to all of you, and have a good weekend and a wonderful holiday. We're adjourned. Thank you. I have read your motion, Ms. Solano. Did you receive a copy of that, Mr. Mays?
No, I did not.
How did you know to be here today?
She told me just a couple hours ago, probably an hour ago. No, last night.
Okay. Ms. Solano, did you have trouble serving him as the court rules required?
Yeah, I haven't been in contact with him as far as in person.
Does he, do you have his mailing address?
I thought I had the correct address. I must have had the wrong one.
Okay, because in order for
and I notified him about it when I motioned it, like that same week. I told his sister about it to tell him.
Yeah, unfortunately, he needs to have a copy of it in order for it to be proper service. Because if I
Okay.
do anything today, it's just gonna get set aside because the service wasn't proper. So what I need you to do is you need to renotice this, and send this all to Mr. Mays at least 9 days before we're gonna be in court, or 7 days if you place it in his hand, okay?
Okay.
Now, my question for you, Mr. Mays, does Miss Solano have your correct address?
Yep,
Is it the address on, Seward or Seward?
yep. 35 Seward. Yep.
Did you say 4 or 3?
My bad. 35 Seward.
Yeah, so you got the wrong address on there, Miss Solano. You got
Okay.
5. So what I need you to do is renotice this and make sure that you give enough time. You don't have to renotice it for 2 weeks. You can renotice it longer if you want to. You just
Okay.
have to get him this at least 9 days before the hearing if you're gonna mail it to him. Or if you're gonna hand deliver it, then it has to be 7 days, but you have to give it to him. You can't like give it to a sister and say, here, give it to him.
Well, I have a PPO on him that I'm going to court for on the 6th too. So
Okay, then mail would work,
okay,
but
Oh,
you
I
have,
didn't know about a court date on the 6th.
there's enough for you to know.
I don't have anything in front of me on that, Mr. May, so to answer that, you might want to pop down to the PPO office. They're on the 3rd floor. They can answer all those questions for you if you want. Okay.
Yeah, I'm definitely in the dark about everything, you know.
All right, well, I'm going to adjourn this so you can get the light of things going on now, and that way you get notice of this thing going forward. So just renotice it.
How do I do that? Do I have to go up to the courthouse and redo the paperwork?
Yeah, but you don't have to redo it. Well, you should have a copy of it, and you just
Okay.
have to do a renotice. They'll show you how to
Okay.
do that on the 5th floor at the
Okay.
Legal Assistance Center. Okay.
Yep.
Make sure you note his correct address, though.
Okay.
All right, then we'll see everybody again. Thanks thanks for your efforts today, and have a wonderful holiday.
Thank you. You too.
So appreciate you.
So, there are 2 motions in this case, and they center on child support. And my first question is, Ms. Bird, did you get a copy of both those motions?
No.
Okay. Mr. Smith, how did you serve those upon Ms. Bird?
I sent this to her digitally because I wasn't able to get to her the same day.
How did that, how did you do that? You emailed it to her?
I sent it through our text messages, yeah.
Okay. Did you get that, Ms. Bird?
I got one of them. Yeah.
Okay. Well, I'll ask you, are you comfortable proceeding today? Or do you need more time?
Yeah, that's fine. We could proceed.
Okay. So let me tell you what I know about this case. Because I've talked to the child support supervisor at the front of the court, because it was kind of hard to figure out what was going on in this. So the last uniform child support order was dated September 13 of this year. So it wasn't that long ago. And that provided for $588 base support, $24 in ordinary medical, for a total of $612 per month starting on June 1 of 2024, plus genetic test costs of $66 which would be paid at an additional $22 per month until those are paid off. The friend of the court, when I spoke to them, indicated that they used the actual income for you, Mr. Smith. Was that income wrong that they used?
No, it's not wrong.
Okay, then I'm kind of curious as to what you're asking me to do. Are you asking me to do something with your child support? Are you asking me to do something with your arrearages? What are you asking me to do?
This is what I'm kind of confused. I just went by what they told me to do. They said that if they said this is the way to say that it's unjust if it's just too much that I couldn't afford. So I was just doing what they told me to do. I'm not sure how to go about it.
Okay. Miss Bird, anything you want to tell me? You're still on mute. There you go.
Oh, okay. Some of the back pay already got excused. Like some of that already got written off. That's all I was gonna say.
Yeah, the friend of the court didn't have any back stuff for you. And even if they have back or what are called arrearages,
Yeah.
they the child support formula says this, that arrearages cannot be more than 2% of what is owed in back support, or $50, whichever is greater. Okay, so the guidelines say I cannot exceed $50 in your case per month, per month to catch up whatever you're behind, but I don't think you're behind anything. So I can do something for you if the income is wrong. If you two were in a marriage and you got stuck with a bunch of bills out of the marriage, I can do all those things. I can also change child support based on the agreements of the parties if neither party child is receiving any assistance at all. If the child is receiving state assistance or any of the parties, then there's not a whole lot I can do about this child support unless the income is wrong. Is there state assistance being received either by you, Mr. Smith, or you, Miss Bird?
Yes.
Okay, then I'm stuck. I'm stuck, Mr. Smith. There's nothing I can do. If the income was wrong, I would be happy to see if the friend of the court can't recalculate it. But if the income is right, then there's not a whole lot I can do for you. Okay.
Okay, that I wasn't sure. This is what they tell me just to do this motion. I was just going by what they said. I didn't know what to expect.
That's fine. But just so you both know, if ever your income changes, and it's a substantial change, then bring it back to me, and either one of you, and we will take another look-see. I don't want anybody paying more support than the guidelines say, and I don't want anybody accepting less than the guidelines say. So in the future, keep an eye on that, and I'm here every other Friday, okay?
So if it's something I can't afford, what do I do? I can't afford to pay it because it's like $600 a month.
Well, the friend of the court has programs, and what I would do, the first step is I would contact whoever your caseworker is and see if they can enroll you in some of those programs to help with that, because that's at least the starting point for trying to figure out how you can get this support under control. Okay, I would call your caseworker probably Monday morning. All right.
Okay, is that it?
Yep, you both are all set. Thank you very much. Have a
Uh,
wonderful holiday and we're adjourned. Thank you.
You too.
I know I thought I saw her in the waiting room. Maybe I didn't, but you are Mr. Pointer.
Yes, Your Honor.
Good morning to you.
Good morning, sir.
So I read your motion, and obviously Ms. Spencer is not here. But let me ask you, it says that on the certificate of mailing that I certify that on this date, and it's dated 11/1, that you served a copy of this motion, a Uniform Child Custody Jurisdiction Enforcement Act affidavit, and notice of this hearing on Ms. Spencer by first-class mail and addressed to their last known address. Is that accurate?
Yes, Your Honor, but it wasn't mailed out the exact date. I probably got it in a couple days later into the
Okay.
mail.
Well, was it mailed to her last known address at least 9 days before today's date?
Yes, Your Honor, and to the address that's in front of you right now, currently. That's the last known address that I have for.
Okay. Is that the address they have on file at the courthouse?
Yes, that's the only address that they have. Yep, from when we had court date with you, July 5th as well.
Okay. So I read your motion. Is there anything you would like to add to it before I ask you a few questions?
Yeah, Your Honor, just, since July, when we seen you since July, Miss Spencer nothing has changed. She pretty much in the same state. And as far as my son wise, he just in better care with me. She hasn't been doing anything as far as like trying to take care of him or, trying to help me out. I've been paying child support still to this day. Paying $130 a week. And pretty much she's just very unstable right now. And like I just know that my son would be better off in care with me. And she knows as well. It's just, that's why I have to do it the legal way.
Right. So the last custody order was this court's judgment of paternity dated December 16 of 2022. And Ms. Spencer was awarded custody. According to the motion, the plaintiff mother is mentally and physically unstable. I know what being mentally unstable means. Has she ever been diagnosed with a mental condition or disorder?
Your Honor, when I obtained my son back in June, she as far as it's in the report of the first report when we came in front of you for the first time, she referred as to you that she wasn't denied. She was basically okay. So I don't know for sure. Like I don't know as far as like doctor notes or anything as far as like what she was diagnosed with, but I'm pretty sure she's going to be in denial in that case.
So you also put in your order or in your motion that Children's Protective Services contacted you to pick up your son.
Yes, yes, Your Honor.
I need you to land somewhere, Mr. Pointer.
Yeah, I am. I'm sorry. I would just make sure he was okay. Sorry about that.
Microphone's going to cut out. All right. So when did CPS call you to pick up your son?
June the 13th, they called me and I went to obtain him June 14th.
Okay. Is there currently an open CPS case?
That I don't know. They contacted me again that my son wasn't involved, but they had to contact me because she had another case open back in August in another county.
What county?
Wayne County.
Okay. All right. Here's how we're going to do this. I'm going to give you everything I can give you today. Okay. Because I can't change custody on a temporary basis without a hearing. Okay. Not a motion, but a hearing. So what I'm first going to do is find that there's been proper cause or change of circumstance to reopen the matters of custody, child support, parenting time. Based on the case of Vodvarka versus Grassmeyer, 259 Michigan Appeal 499, a 2010 or 2004 case, I find proper cause or change of circumstance has been shown. The relevant best interest factors pursuant to MCL 722.23, first of all, there would implicate is factor B, factor D, factor E, factor G, especially. All those factors would certainly be implicated by what's alleged in the motion. So what I'm going to do is I am going to reopen everything, custody, support, parenting time, and send the matter to the friend of the court for an investigation and recommendation. The fee for that is, are you currently working, Mr. Pointer?
Yes, I am, but I'm currently, pretty much it's kind of high right now because I'm still paying child support, and I have to pay.
I'm gonna stop that for you.
Well, currently, it's right now. I think I'm only paying arrears.
Okay,
I
then
believe so.
I can't stop for you, but I can stop your. It sounds like they've already stopped your.
Yep.
So what I'm gonna do, and generally I do not do this, Mr. Pointer, but I'm going to do this in your case because I don't want there to be any delays. I am going to waive the fees for the evaluation for you. So I'm gonna order it at the front or complete investigation and recommendation. If you want me to consider while the friend of the court is doing their investigation, if you want me to consider a temporary change of custody, you're going to have to schedule another motion and you're going to have to be very specific. I'm going to need something from CPS that says that she is currently being investigated, and I'm gonna need something from that same person saying that you should pick up your kid in June, and you can bring that back to me in a motion, but I'm gonna give you everything I can do today, okay?
Okay.
All right, I will do that order today. You should be hearing from the friend of the court in a week to 10 days. And like I said, if you want me to consider temporary custody with you, you're going to have to file another motion and you're going to have to be very, very specific as to what's going on in Miss Spencer's life that requires me to do something that fast, okay?
Well, I mean, Your Honor, pretty much have nothing changed since we had court the last time.
I understand. And I'm going to, like I said, I'm going to grant your motion, but I can't stop someone's, I can't change custody on a Friday morning. Okay, I can't do that.
Correct.
So you're going to have to file something else, and that will at least get me to consider whether I need an evidentiary hearing on temporarily having you be the custodial parent until such time as the friend of the court is done with their recommendation. Okay.
Okay, so am I in the wrong for keeping my son safe?
I can't answer that. If CPS has done that, then you better come at it with verification from CPS because I need to know what's going on.
Okay.
Okay. All right, you're all set. Have a great
All right.
weekend and a wonderful
You too.
holiday. Okay?
You too. Thank you.
You filed a motion about child support. Is that right?
Yes.
How did you let Miss Hammond know what we're doing today?
She know that I'm here to see if I can have my child support reduced.
Okay. Because you didn't, what the law says I have to do is before I can do anything, it has to be properly served on Miss Hammond, and I can't tell from your motion if you did that. So does she have a confidential address, or do you know where it is?
She has an address, but I don't know it, but I just know what street she live on. But I did serve her the papers.
How? Did you hand it to
By
her?
hand. By hand.
When did you hand it to her?
It was the same day when I filed a motion.
Okay. So it looks like she's been properly served and just chose not to be here. Let me tell you what I know, Mr. Smith. According to your motion, the last uniform child support order was entered on May 31st of 2023. That provided that you, Mr. Smith, pay $608 per month in child support, and the motion simply says you can't afford it. See, I can't do anything unless you tell me that has anything changed since the order was entered last year. Do you make less? Do you have more overnights? Do you have additional children? Tell me something in your life that's changed, because otherwise I can't stick my nose in your stuff just because you can't afford it. Make sense?
Yes.
So tell me what's changed since May 31st of 2023. You get a new job?
Actually, I just got laid off from a job, but I'm in the process of looking for one, which
Okay.
that's what I'm about to do.
That's a change of circumstance. So now I can talk with you. So it's certainly, when you do not make the income you did, it's certainly cause for me to reopen child support and take a look at it, okay? So I'm going to do that for you. I'm going to refer it to the friend of the court for support review. And I will do that order today. You'll hear from them probably in the next 7 to 10 days. And they're going to ask you for a bunch of stuff, okay? They're going to ask you for any wage information, the layoff information, and you can even call the friend of the court caseworker right now and tell them you've been laid off, and they may just stop your child support until you become reemployed. I don't know that, but I'll do everything from my end to get the friend of the court to take another look at your support, okay?
Okay.
All right. I will prepare that order today, and it'll get sent over. You're all set with me, Mr. Smith.
All right.
Thank you. I have reviewed your motion, Mr. Hage. Did you receive a copy of that, Ms. Kirkland?
Yes.
Okay. Anything you want to add to it, Mr. Hage, before I turn to Ms. Kirkland for her response?
No.
Okay. Ms. Kirkland, any response that you have?
Yes, so after reviewing the order, he is asking for every other weekend, but as far as in reduced child support, but he hasn't gotten her any more time. Like, there hasn't been any more excessive overnights or anything, except, as he said, this past summer when he wasn't even paying support because he had 2 broken feet. So support just started back up in September. So I don't think there needs to be a reduction because he's not getting her more at all. This past weekend, he just had her, and then he asked to keep her overnight, I believe this past Tuesday, but I told him no because she's lives with, like, I'm her primary parent. She goes to and from school from my house. So I told him I didn't want to disrupt her school weeks and that he could get her on the weekend. There's never been an issue. When he asks to get her, he gets his child. So this was filed basically, I feel like, out of spite because things didn't go his way, and he called the police and then started refusing to give her to me or tried to keep her from me.
What is your current you're jumping around on me, Ms. Kirkland.
I'm
Can you-
sorry, it's just a lot to get out. Go
No,
ahead.
I understand that, but your camera is jumping around. There we go.
Oh, sorry.
That's all right. So, yeah, you're jumping around again. Can you put it stationary somewhere?
Yes.
Okay, there you go. Because see, what happens is when the camera moves, you cut out and I can't hear a lot of what
Oh,
you're.
I'm sorry.
That's all right, but I heard pretty much most of it. Let me ask you this. On paper, what is his current parenting time schedule?
We don't have anything on paper. It, like I said, whenever he asks for her, he gets her. We've never had any issues communicating or exchanging the child up until October when he was up. It's in the motion as well about the rental car. I went out with the rental car. He was upset, called the police for an exchange of custody, and then refused to give her to me. The police had to convince him to give her back to me so that, you know, we could continue our work and school week. So, like I said, up until this past October, that's when this issue started. And because he did refuse to give her back to me, I didn't feel comfortable with her going there overnight, although he didn't ask for her either.
That's what my question's going to be.
Okay.
How comfortable are you two operating with no written schedule?
I'm still perfectly fine with it. He can literally text me or call her, hey, can I get her? It's always yes. I've never denied him parenting time, ever.
Okay. So, I mean, if there's, because see, it creates a lot of problems when things aren't in writing.
Absolutely.
People can say different things. You can be under one understanding and not the other. To me, it sounds like the root of these problems is because you guys don't have anything in writing. And I think you do need something in writing.
Yes.
I really do. Because this sounds like really not a support motion. It sounds like more of a parenting time issue. And I agree with parents that if it were me, I'd want something in writing so I know when he's going to be there to pick up the child, when he's going to bring the child back. So Mr. Hage can know when to come and pick up the child, know when to bring child back. That all should be specified in what's called a written order. And I think that's at least what this motion sounds like to me more of anything.
Absolutely.
So here's what I'm going to do. I can't change anything on a Friday morning. The law doesn't let me do that. But I am going to send parenting time to the friend of the court to see if they can't help you both work out a schedule. That I think is important. So both of you know how to operate here. And they're also going to take a look at support because as the schedule changes, because support is based on things like not only how much money you make, but how often you have the child overnight, those types of things. So I'm going to send those two issues to the friend of the court for an investigation and recommendation. Now, here's the issue. Mr. Hage, are you currently working?
Yes.
Ms. Kirkland, are you currently working?
Yes.
You think you guys can come up with $150? Because that's what it costs for the friend of the court to do their business.
Sure. If we can split the cost.
Well, it's 300. That's splitting it, 150 apiece.
Okay. Yeah.
Okay. All right. So I'm gonna send both of those issues to the friend of the court, and they're gonna meet with both of you first. And they're
Okay.
gonna see if they can't hammer out something to put on paper. But if they can't, they will do a deep dive into it. They'll talk to people you want them to talk to, witnesses, character references. They'll do all that stuff. And then they will make a recommendation to me. And
Okay.
then the parties will get sent a copy of that recommendation. And then the parties are free to accept it. They're free to accept some of it and then can negotiate the other part. They're free to completely disregard or object to it. And if they do that, then the law says I got to hold a hearing, like a trial, on child support parenting time. I really don't want to do that, but that's really the only option I have because I can't change things on a Friday morning. The law says I have to have evidence, and I have to do that in an evidentiary hearing. But I can sign the order today, sending it to the friend of the court for child support and parenting time, because I do find that there's been proper cause or change of circumstance to at least open those two issues up, because it sounds like there's just poor communication and lack of cooperation. And I do believe that constitutes change of circumstance. The relevant best interest factor is MCL 722.23J. So I will do that today, and you'll be hearing from the friend of the court in probably the next, you got to make the payment in, I think, 14 days. So I will also ask both of you if there's any questions about whether the court has your right addresses, because if there is, then you got to make sure to go down to the courthouse and the friend of the court and make sure they do, because they don't forward mail. And I would hate for this to stop in its tracks because they don't have your right address. Okay?
Okay.
So I'll get busy doing that today. All right?
All right.
You'll be hearing from them shortly. All right, Mr. Hage?
And if we don't make the $300 payment, what happens then? The hearing?
It shuts down.
The
They
whole
stop.
thing shuts down?
Yep. They won't proceed without the payment.
All right.
All right, you're all set. Thank you both very much and have a great